Call me a second time, and it's contempt. This is my one free gripe today. Actually, though, I think the court should be commended because, for the most part, the court has been very zealous in guarding the protections that are afforded under Article 11 in the efforts by most local governments that have adopted self-governing powers to utilize those provisions effectively in the interests of their citizens. There have been a few cases that have caused us some concern over the years. One of them in particular involved the city of Helena back in 1983. That involved the efforts of the city of Helena to adopt a business licensing system and ordinance. And that ordinance was held inapplicable as it related to the practice of law. And I remember the power issue was argued very ably by Jeff Sherlock, who was then the city attorney. He's gone on to become one of our better district judges. But one of the sad things about that decision is that while the court, I think, was legitimately trying to address what was its power to regulate the practice of law, there's no doubt that it has that power, the court did not indulge any presumption of constitutionality of the ordinance as it related to the power of the city to enact the ordinance. And it did not even mention or reference the fact that all reasonable doubts in favor of the ordinance needed to be considered. They simply bypassed those. More recently, in the Montana Dakota Utilities versus City of Billings case, the court had to deal with an effort by the City of Billings to impose a franchise fee system in connection with what I think all of us would recognize is the right of the city to control and direct the franchise for the operation of public utilities. The majority of the Supreme Court felt that what the city was trying to do was enact a tax, which again the legislature had not specifically authorized, and the court went through a lengthy analysis of its decisions on that issue and concluded that in this instance the exercise of that authority was inappropriate. Justice Cotter, I'm pleased to say, issued a very short, concise, and I think very accurate dissent in which she pointed out that the court had not analyzed the issue correctly. And it was not a question of taxation as much as it was how is the city going to implement its authority that it clearly has with respect to franchise rights. And I love her quote in there, we, meaning the majority of the court, she says, we have overanalyzed this question. Marvelous statement. They did. That's my one free gripe, I guess, today. Just by way of some concluding remarks, again, I think that Article 11 has been one of the best changes both in theory and in practice, and I applaud the convention for considering it and adopting it. And I don't know if all of the voters who voted in 1972 fully appreciated it, but I certainly do as an elected official. It's been, I think, the consensus of many of my colleagues, particularly those around the state who are in communities that have the right of self-governing powers, that this has worked very well for us. My friend Jay Dunkel commented to me recently that even in the small community of Choteau, it has given their city government a level of certainty in what they were doing that they did not have before, and I think that says it all. As Jim pointed out, though, our sister governments, the counties, have not fully taken advantage of this option. And it's very unfortunate. I think there's reasons for it, and I can certainly address that in the question and answer session afterwards. But on the subject of taxes, I think that we need more respect from the legislature on this subject. Quite frankly, we await a 21st century Moses who can approach the federal legislature and convince them to let my cities, towns, and counties go. And if I can carry that biblical analogy one step further, we are also going to have someone with a heavy hand there to make sure that Pharaoh does not take away with one hand what it gives or what he gives with another. Thank you very much.
We're going to move right into the question and answer. Go ahead.
Representative Sands here, and I am not Moses, but I have suffered several sessions serving on the local government committee and judiciary, which I love. So I wanted to ask you a question and make one comment. First of all, when we talk about states' rights, the legislature forever grates under the authority of federal government, sometimes intervening, telling us what our speed limit has to be, this, that, and the other thing, which we deeply resent on both sides of the aisle. Yet every time it comes to issues of local government having the authority, we routinely don't trust them at all and like to micromanage, I believe, to an inordinate amount in all kinds of issues. And given the size of our state and the problems that Western Montana has, needing sometimes a much greater authority to do regulation, and in Eastern Montana, which is smaller and doesn't have the capacity to deal with that level of organization sometimes, and the problems of the Bakken, what would you say about addressing the issue of giving county governments more authority and trying to reverse the Dillon rule? Has there been any attempt or discussion about either, does the Constitution adequately address that? Is there a movement or a reflection on your part that we should try to, in some structural way, address that situation that allows more discretion on the part of counties, more power on the part of counties to have the authority to be able to adopt regulatory powers to do what they need to do, which can be very different in Macomb County than in Missoula County.
Is that directed to one of the panelists
or all of you? You were
Okay.
all much more objective
Okay.
about that than those of us who have done their own in schools. I appreciate your comments.
Well, Representative Sands, you raised a very good point, and I think probably the 2013 legislature will have to address that, because I listened to my colleague Brett Smelzer and my other colleague Jerry Jemison and Mayor Glendive discuss this very subject the other day, that cities and counties in northeastern Montana are hamstrung in their ability to deal effectively with issues. It would be nice if our legislature met every year where they could perhaps give them authority to address that, but that's not going to happen. We all know that. My preference would always be that initially that the local communities decide what would be best for them in terms of the structure or form of government to address it. But consistent with that, I would like to see the legislature, again, free up the ability of local communities to have the power to deal with those issues as they see fit. And again, the taxation authority there, I think, would be a key to that answer.
I'll respond just quickly, then I'll take the second question. In working with charter commissions throughout the state, especially in the rural areas, and with county charter commissions, in bringing up the issue of self-government powers, county people routinely said that we don't need self-government powers because we have them already, because we do what we want anyway and no one says anything. So I don't know if that's so.
In some of our larger cities, the budgets are millions of dollars and the issues are incredibly complex. And yet we expect people to serve either as in alderman mayor system or as commissioners, mostly as volunteers. Unless they require no sleep, or they're independently wealthy or retired or have a working spouse, we can't recruit younger people who have families to support to do this. When study commissions are looking at alternative forms of government, is there some way to look at the alternative of paying for these people so that this can become their full-time job?
Most of the elected officials get small stipends, so that's written within the MCA, the Montana Code, that they can set their own salaries for the officers of local government. But there is I think that's an important point to make, that without sufficient compensation, you're not going to attract quality people. And those communities that have recognized that have bumped up their compensation, even in the smaller rural communities. The challenge with having a professional staff, like a commission manager form of government, is it's expensive to hire someone that has the capacity to manage the affairs, or the community may not be complex enough to warrant having someone on either full-time or even part-time. The larger communities, though, like Billings and Helena, they have professional staff, usually a commission manager form of government that allows them to weigh in those very complicated issues and then bring forward to the governing body a range of alternatives and allow them then to deliberate over the distilled part of those issues. So it's a little bit more efficient than having these basically volunteer folks, down in the weeds, so to speak, trying to really understand the complexity of these issues. The staff does that and then brings that forward through the executive branch or the manager.
Okay. Right there on the aisle.
Yes, Dan Harrington. I guess one of the questions dealing with the taxation of local government, one of the things that happened during the Constitutional Convention was the state gained the most of the power as far as taxation and appraisal and assessment of property. In other words, the power was shifted from the Department of Equalization at that time. And I'd like to get your feeling on that, but I would also like to kind of comment on the fact why that occurred, because of the fact that there were so many problems because of corporation domination as far as the taxation power was beforehand in most counties, not just Butte, Silver Bow or Anaconda, but in most counties throughout the state. But I would also like to just comment on myself that as a legislator, I always voted to give the counties the right to vote on this. I never once voted for a sales tax, but I always gave the right to the counties because I thought that was important, that they were going to take that back for a vote of the county, and I felt that was very important. As long as they were going to vote on that issue, the local counties should have that power to do that. But that's kind of what I. Thank you very much.
Yeah, I'll try to address the equalization issue because it does have some tie into what we do. I remember there was quite a bit of discussion at the time about the fact that prior to 1972, property tax assessment was done on a county-by-county basis, and there were a number of disparities and inequities that had arisen on that particular subject. And I think on the one hand, the delegates were probably correct to try and address it and turn it into more of a statewide assessment system. However, I can tell you that even after 40-some years, I continue to hear complaints from a lot of local government officials that we also have problems with the statewide assessment system, which I think in the end are more practical problems in terms of trying, to develop it and make it work so that cities, towns, and counties have accurate information on a timely basis so that we can make determinations on what we do with respect to the property tax. But that's my perspective.
Okay, another question. Pat?
My question goes to administration and cost. Given both the geographic size of Montana as well as our small population, do Montanans have too much government?
Go ahead, Dan.
Yeah, go ahead, Dan.
Take that one, Dan. Let's talk about school districts while we're at it. Yes. They're in that, I think there's some challenge. I think in the municipal side, where there's small clusters of people living in close proximity, I think we can't do much about that. There might be cause in some counties to do a consolidation city-county government. And then counties, I think there could be an argument for both counties, school districts, and many other of our jurisdictions to consolidate. And I think that is a very difficult proposition because all government is local. And I think this, back to your question, I think the spirit of the Constitution, particularly Article 11, is that the spirit of my assumption is the delegation is that they want the local folks to decide how to govern themselves, giving them that power, but yet we can't.